Good morning, everyone, and welcome to my channel. Today, we are going to do the suspension chapter number 3, the general orders of the suspension. So, here we begin. It says guiding principles for placing a government servant under suspension. क्या क्या guiding principles है जिनकी वजह से आप जो है एक government servant को suspension कर सकते हैं, ठीक है? तो the guiding principle it has been decided that public interest should be the guiding principle. तो आपसे पूछा जाए कि क्या है exactly गाइडिंग प्रिंसिपल क्या है? तो पब्लिक इंटरेस्ट शुड बी द गाइडिंग फैक्टर इन डिसाइडिंग, ठीक है, इन डिसाइडिंग द इन डिसाइडिंग टू प्लेस अ गवर्नमेंट सर्वेंट अंडर सस्पेंशन एंड द डिसिप्लिन अथॉरिटी शुड हैव द डिस्क्रिशन। और जो ये जो भी आपकी डिसिप्लिन अथॉरिटी है ना इस केस में, ठीक है, should have the discretion to decide this taking all factors into account. However, the following circumstances are indicated in which a disciplinary authority may consider it appropriate to place a government servant in suspension. They are only intended for guidance, ठीक है, and should not be taking mandatory, ठीक है. These are only for guidance. ठीक है, cases where continuance of the in the office of government servant will prejudice the investigation, ठीक है. अगर जहाँ पर मान लीजिए कंटिन्यूस जो है इन ऑफिस ऑफ द गवर्नमेंट सर्वेंट विल बी प्रेजुडिस इन इन्वेस्टिगेशन, ट्रायल या इंक्वायरी पर होगा, ठीक है, या फिर जहाँ पर वो टेम्परिंग वगैरह कर सकते हैं, ठीक है, और विद द विटनेस और द डॉक्यूमेंट्स, तो इस तरीके वहाँ पर वेयर द कंटिन्यूस ऑफ इन द ऑफिस इन दी ऑफिस ऑफ द गवर्नमेंट सर्वेंट इज लाइकली टू सीरियसली सबवर्ट डिसिप्लिन, अगर वहाँ पर जहाँ पर सबवर्ट करा डिसिप्लिन इन द ऑफिस इन विच द पब्लिक सर्वेंट इज वर्किंग, ठीक है. तो मान लीजिए किसी ने करप्शन वगैरह किया तो उन पर्सन को आप कैसे अलाउ करेंगे? वेयर द कंटिन्यूस इन द ऑफिस ऑफ द गवर्नमेंट सर्वेंट विल बी अगेंस्ट द वाइडर पब्लिक इंटरेस्ट, जहाँ पर वाइडर पब्लिक इंटरेस्ट के अंडर में नहीं होगा, अदर देन दोज कवर्ड बाय 1 and 2, जैसे पब्लिक स्कैंडल, अगर मान लीजिए किसी ने पब्लिक स्कैंडल कर दिया एंड देयर इज नेसेसिटी टू प्लेस द गवर्नमेंट सर्वेंट अंडर सस्पेंड टू डेमोन्स्ट्रेट द पॉलिसी ऑफ द गवर्नमेंट टू डील स्ट्रिक्टली विद द ऑफिसर्स इन्वॉल्वड, ठीक है. Where allegations have been made against a government servant and the preliminary inquiry has been revealed, ठीक है. एलिगेशन जो है दैट हैज़ बीन मेड अगेंस्ट द गवर्नमेंट सर्वेंट, और प्रीलिमिनरी इंक्वायरी जो है ना, प्रीलिमिनरी इंक्वायरी दैट हैज़ रिवील, उसने क्या रिवील किया है? दैट अ प्राइमा फेसी केस इज मेड आउट विच वुड जस्टिफाई द हिज प्रोसिक्यूशन, मतलब उसको दोषी माना जाएगा एंड और ही इज बीइंग प्रोसीडेड अगेंस्ट डिपार्टमेंटल प्रोसीडिंग्स, या फिर इनको जो है प्रोसीडिंग्स डिपार्टमेंट प्रोसीडिंग्स में चलना पड़ेगा, ठीक है. तो इस केस में आप प्राइमा फेसी जहाँ पर आपको लग रहा है एंड वेयर द प्रोसीडिंग्स आर लाइकली टू एंड इन इट्स कन्विक्शन, और जहाँ पर आपको लगता है कि जो इनकी जो प्रोसीडिंग्स है ना, दे आर लाइकली टू एंड इन कन्विक्शन और डिसमिसल, तो वहाँ पर जो है आप कर सकते हैं रिमूवल तरीके से, या फिर कंपल्सरी रिटायरमेंट. तो इन द फर्स्ट 3 सर्कमस्टांसेस द डिसिप्लिनरी अथॉरिटी में एक्सरसाइज हिज डिस्क्रिप्शन, जहाँ पर हम तीनों की बात करें ऊपर 3 में, इनकी फर्स्ट, सेकंड और 3, इन दीज केसेस में वो अगर चाहें तो अपनी डिस्क्रिप्शन यूज़ कर सकते हैं, ठीक है, डिस्क्रिप्शन यूज़ कर सकते हैं इन तीनों केसेस में. कौन है? जो भी आपकी डिसिप्लिन अथॉरिटी है दैट कैन एक्सरसाइज द डिसिप्लिन अथॉरिटी टू प्लेस अ गवर्नमेंट अंडर सस्पेंशन इवन व्हेन द केस इज अंडर इन्वेस्टिगेशन और बिफोर अ प्राइमरी फेज केस इज मेड आउट. भी बोलता है सर्टेन टाइप्स ऑफ मिसडिमिनर वेयर सस्पेंशन में बी डिजायरेबल इन फोर सर्कमस्टांसेस मेंशन्ड, जहाँ पर जो है सस्पेंशन डिजायरेबल है, मतलब आपको करना ही है, ठीक है, जहाँ पर जो है सस्पेंशन जो है वो डिजायरेबल है. तो एनी ऑफेंस और कंडक्ट इन्वॉल्विंग मॉरल टर्पिट्यूड, जब भी कोई भी ऑफेंस या कंडक्ट जिसमें मॉरल टर्पिट्यूड आता है या फिर करप्शन होता है, ठीक है, एम्बेजलमेंट या मिस अप्रोप्रिएशन ऑफ द गवर्नमेंट मनी, ठीक है, पोजीशन ऑफ डिसअप्रोप्रिएट एसेट्स, मिसयूज ऑफ ऑफिशियल प्रॉपर्टी और सॉरी पावर फॉर पर्सनल गेन, तो ये है. दूसरा आपका सीरियस नेग्लिजेंस, ठीक है, फॉर डिरेक्शन ऑफ ड्यूटी रिजल्टिंग इन कंसिडरेबल लॉस टू गवर्नमेंट, ठीक है. देन वी हैव desertion of duty or refusal to deliberate failure to carry out written orders of the superior officers. In respect of the type of misdemeanor specified in clause 3 and 4 and 5, discretion has to be exercised with care, ठीक है. कौन से में? 3, 4 और 5 में जो है क्या लेनी है आपको? डिस्क्रिप्शन लेनी है, ठीक है. फिर बात करते हैं रीजन फॉर सस्पेंशन इज इफ नॉट इंडिकेटेड इन सस्पेंड ऑर्डर इटसेल्फ शुड बी कम्युनिकेटेड विद इन 3 months. अगर मान लीजिए आपने जो है रीज़न नहीं बताया उसके अंदर, ठीक है, आपने सीधा सस्पेंड कर दिया कि किस रीज़न, तो इट शुड बी कम्युनिकेटेड विद इन 3 months के अंदर अंदर आपको उसका रीज़न बताना है कि इस रीज़न से जो है आपको, सो दैट यू कैन गो टू अपील. इंस्ट्रक्शन अबाउट टू बी फॉरवर्ड स्ट्रिक्टली. देखिए, since the suspension of public sector on a serious charge like corruption is directly dealt with the vigilance administration, the commission hereby desires that all disciplinary authorities should follow the instructions strictly. It is also desired that if the CBI recommends suspension of a servant, ठीक है, if the CBI recommends suspension of a public servant and the competent authority does not propose to accept the CBI recommendation in this regard, देखिए जहाँ पर CBI प्रपोज करती है कि रिकमेंड करती है अपनी तरफ से कि भाई इसको जो है सस्पेंड कर दिया जाना चाहिए, लेकिन जो कॉम्पिटेंट अथॉरिटी है and does not propose to accept the CBI's recommendation in this regard, then it may be treated as a case of difference of opinion between this. ठीक है, that's treated as a case of difference of opinion. ठीक है, between the CBI and the administrative authority, and the matter may be referred to the commission for advice. फिर इसके लिए जो है the matter जो है that may be referred to the commission for advice. ठीक है, कौन सी commission? आपकी vigilance commission. ठीक है, it also that if a person had been suspended on the recommended CN, CBI may be consulted if the administrative authority proposed to revoke the suspension order. The CBI may be consulted if the ठीक है, अगर जहाँ पर CBI ने प्रपोज किया, ठीक है, ये आपकी विजिलेंस है, यहाँ पर विजिलेंस कमीशन. तो अगर मान लीजिए CBI ने प्रपोज किया अपने तरफ से, द if it also read that if a person has been suspended, if a person had been suspended on the recommendation of the CBI के recommendation में कर दिया, and if the तो CBI को आपको कंसल्ट करना है, मे बी कंसल्ट इफ द एडमिनिस्ट्रेटिव प्रपोज टू रिवोक द सस्पेंशन ऑर्डर. ठीक है, सस्पेंशन ऑफ गवर्नमेंट सर्वेंट इन्वॉल्व इन केसेस ऑफ डोरी और डेथ्स. ठीक है, डोरी डेथ के सस्पेंशन क्या है, क्या बोलता है इसके अंदर? सब रूल 1 बोलता है प्रोवाइड इंटरली दैट गवर्नमेंट सर्वेंट मे बी प्लेस्ड अंडर सस्पेंशन वेयर डिसिप्लिनरी प्रोसीडिंग अगेंस्ट हिम इज कंटेम्प्टेबल. यहाँ पर भी जो है ये रूल हमारा 10(1) बोलता है. ठीक है, 10 बोलता है दैट a government servant may be placed, a government servant जो है that may be placed under suspension where a disciplinary proceeding against him is contemplated. जहाँ पर भी कंटेम्पलेट होता है कि हाँ इसके अगेंस्ट जो है डिसिप्लिनरी प्रोसीडिंग चलेंगी, इस कंटेम्पलेट और इज पेंडिंग, और वेयर अ केस अगेंस्ट हिम इन रिस्पेक्ट ऑफ क्रिमिनल ऑफेंस इज अंडर इन्वेस्टिगेशन. ठीक है, इंक्वायरी और ट्रायल. So the sub rule 2 of the same rule alleged under government servant shall be deemed to have been placed under suspension by an order of the appointed authority with from the date of his detention. ठीक है, if he deemed in custody whether on a criminal charge or otherwise for a period exceeding 48 hours. As the government servant take a serious views of offences against women, government has reviewed the provision in the rules in regard to placing government under suspension, and if he is accused in involving in a case of dowry death as defined in section 304 of the IPC, which reads as follows, that where the death of a woman is caused by any burns or bodily injury, where the death of a woman is caused by burns or bodily injury or occurs otherwise, okay, then under normal circumstances, then within 7 years of her marriage, okay, and it's shown that soon before her death she was subjected to cruelty, or harassment, or by her husband or any relative of her husband, or in connection with her any demand for dowry. Because such death shall be called dowry death, and such husband relative should be deemed to have caused her death. For the purpose of this subsection, dowry जो है shall have the meaning of shall have the same meaning as in section 2 of the Dowry Prohibition Act. In a case has been if a case has been registered for the by the police against a government servant under section this, then he shall be placed under suspension. ठीक है, तो ये बोलता है if a case has been registered by the police against the government servant, then he shall be placed under suspension in the following circumstances of the competent authority by invoking the provision of this. If the government servant is arrested in connection, अगर उसको arrest करा, if a government servant is arrested in connection with the registration of the police case, he shall be placed under suspension immediately in respect of the period of his detention. ये बहुत इंपॉर्टेंट है, दैट irrespective of the period of detention. मतलब यहाँ पर आपको 48 आवर्स का और इस तरह का कुछ भी नहीं है, जैसे ही होगा उसको आप सस्पेंड कर देंगे सीधे से. इफ ही इज नॉट अरेस्टेड ही शिल बी प्लेस्ड अंडर सस्पेंशन. बोलता है इफ ही इज नॉट अरेस्ट नहीं किया था, दे शिल बी प्लेस्ड अंडर सस्पेंशन immediately on submission of police report, and he should be immediately on a police report under section 2 of the Code of Criminal Procedure to the magistrate. Okay, observing this, if the report prima facie indicates that the offence has been committed by the government servant. ठीक है, अगर जो प्राइमा फेसी जो है ना, if the report जो है प्राइमा फेसी indicate that the offence has been committed by the government servant, तो इस केस में आप उनको सस्पेंड कर देंगे. ठीक है, और if government servant is arrested, तो आपको irrespective of the period of his detention, he shall be placed under suspension. उसको आप सस्पेंशन कर देंगे, सस्पेंड कर देंगे. ठीक, नेक्स्ट बोलता है रिपोर्ट ऑफ अरेस्ट टू सुपीरियर्स बाय गवर्नमेंट सर्वेंट. Will be due to the government servant who may be arrested for any reasons to intimate the fact of his arrest. तो आपको इंटीमेट करना है. ठीक है, इंटीमेट द फैक्ट ऑफ हिज अरेस्ट एंड द सर्कमस्टेंसेस कनेक्टेड देयरविद टू हिज ऑफिशियल सुपीरियर promptly even though he might have subsequently been released. ठीक है, the arrest official superior promptly. ठीक है, even though जो है अगर even though he might have been subsequently been released on trial. On receipt of the information from the person concerned or from any other source, the department authority should decide whether the fact and the circumstance leading to the arrest of the person called for his suspension or not. Failure on the part of government servant to so inform his official will be regarded as suppression of material. ठीक है, अगर आप इस ऐसा करने में फेल हो जाते हैं, राइट, डिपार्टमेंट अथॉरिटी जो है on receipt of information, then an authority should decide whether the fact leading to arrest of a person call for suspension. ठीक है, फेलियर ऑन द पार्ट के अलावा बात करते हैं कि फेलियर जो है ऑन द पार्ट ऑफ द गवर्नमेंट सर्वेंट so inform his official superiors will be regarded as failure in the part, this will be regarded as suppression of material information and will render him liable to disciplinary action on this ground alone, apart from action that may be called for an, for on the outcome of the police against him, police case against him, ठीक है, and will render him liable to disciplinary action on the ground alone, ठीक है, apart from the action that may be called for an outcome of the police against, सिर्फ इसी ग्राउंड पर ही आप उन पर एक्शन करते हैं and will render him liable to disciplinary on the ground alone, ठीक है. State government have been requested to issue necessary instructions to the police authorities under their control to send of arrest the let set of central government servants to the let official superiors as soon as possible after the arrest or release, indicating also the circumstance to enable them to decide what action be taken against such employees. बोलते हैं need for issue of suspension order in detention cases. Need for issue of suspension orders in detention cases, yes. बोलता है the question whether a formal order placing government servant in suspension with reference to this should be issued has been under examined. The Ministry of Law has advised that it is desirable for the purpose of administration court make a formal order with reference to uh, detention cases, ठीक है. रूल 10 ठीक है. A standard form of order is to be issued, ठीक है. तो बोलता है the question whether a formal order placing a request, yes to make a formal with reference. जब भी जो है डिटेंशन केसेस आता है तो आपको अपनी तरफ से एक फॉर्मल रिव्यू शुड बी इशूड. तो बोलता है डीम्ड सस्पेंशन टू कंटिन्यू टू बी ऑपरेटिव अनलेस मॉडिफाइड और रिवोक्ड. डीम्ड सस्पेंशन जो है टू कंटिन्यू टू बी ऑपरेटिव अनलेस मॉडिफाइड और रिवोक्ड, ठीक है. हाँ, मॉडिफाई रिवोक नहीं करें तो चलती रहेगी. अदर रूल प्रोवाइड दैट द गवर्नमेंट सर्वेंट शैल बी डीम्ड टू हैव बीन प्लेस्ड अंडर सस्पेंशन by an order of the appointing authority with effect from the date of his detention, ठीक है. if he is detained in custody whether criminal or otherwise for a period of exceeding 40 hours. ये हमारा रूल 10(2) बोलता है आपका, ठीक है. रूल 10(2) क्या कहता है आपका? रूल 10(2) आपका बोलता है, ठीक है. ये बताया a question whether the order of suspension in case of whether the order of suspension in case covered in a case covered under rule 10(2) this has a limited operation for the period of detention and not beyond it. A question whether the order of suspension in a case covered under rule 10(2) of the CCS CCA has a limited operations for the period of detention and not beyond it was considered the Supreme Court in the case of this for allowing the appeal of the case. Supreme Court has said the order in terms of this not written in points of duration or efficacy the actual period of detention. It continues to be operative unless modified. होता है यहाँ पर it's not 10(2) rule जो है rule 10(2) is not restricted point of duration or efficacy the actual period of detention. It continues to be operative unless modified or revoked. Okay. Ministry Department request to bring this Supreme Court, ठीक है. Supreme दे दिया है. Appropriate refer to non cases where the question of validity to continue suspension after release from considered before High Court. Minister requested to bring up the above ruling of the Supreme Court to the notice of all concerned that the same is appropriately referred in all cases where the question of validity of continued suspension comes up for consideration, ठीक है. अब कंटिन्यू रहेगा. गाइडलाइंस फॉर फर्दर एक्शन ऑन एक्विटल, तो बरी कर दिया तो उसके क्वेश्चन हैज बीन रेज्ड वेदर रिगार्डिंग द स्कोप ऑफ एक्शन दैट कैन बी टेकन against a government servant who is dismissed removed community for service has been set aside, ठीक है. जो है इसमें क्वेश्चन हैज बीन रिगार्डिंग द स्कोप ऑफ एक्शन इन केस dismissal, removal or complete retirement from the service has been set aside or declared or rendered void in consequence by a decision of the court of law, ठीक है. As certain with the disciplinary authority taken into account while taking recourse to rule 10 for it is clarified for the information to also abundant that the further inquiry contemplated in this rule should not be ordered except in a case clarify that the further inquiry is then the further inquiry contemplated in this rule should not be ordered except in a case when the penalty of dismissal removal has been set aside by court law on technical. ये important है. except in a case where the penalty of dismissal, removal or compulsory retirement has been set aside by court of law on technical without going into the merits of the case or when fresh material has come light, ठीक है. इसके अलावा जो है और when fresh material has come into light to the was not before the court. A further inquiry into the charges which have not been examined by the court can however be ordered by the department authorities and the rule depending on the facts and the circumstances which एम्पावरिंग ऑल सुपीरियर, ये बहुत इंपॉर्टेंट है ये वाला पॉइंट भी, कि वो करने के बाद भी जो है फर्दर इंक्वायरी, क्या कह रहे हैं आपका केस में बोलता है दैट a further inquiry into the charges which have not been examined by the court however be or may however be ordered, ठीक है, by the department of effects, empowering all superiors to suspend their subordinates in its in its reporting person with the ARPG अपने तरफ से recommend किया that all supervisor officers should be empowered to suspend a subordinate officer in circumstances disclosing gross direction of duty, however to review of the suspension within a short time by the next higher authority, so that however to review the order within a short time by the next has been accepted by the following modification. Only supervisor officer in office located away from headquarters need be specifically empowered. Only होता है only supervisory officers in office located away from headquarters need be specifically empowered to suspend a subordinate officer in case involving gross dereliction of duty. होता है only, बोला है only supervisory officers, supervisory officers in the office located away from headquarters need be specifically empowered to suspend someone in case involving gross dereliction of duty. In order to prevent abuse of this power, the suspending authority should be required to report the facts. Further, the suspending authority जो है that should be required to report the facts of case immediately to the next higher authority. All such orders of suspension should become ab initio void unless confirmed by the reviewing authority within a period of 1 month from the of order. ये भी important है that all such orders जो है suspension should become ab initio, खत्म हो जाएंगे void unless confirmed by the reviewing authority within a period of 1 month में उसको बताना पड़ेगा. As the Ministry of Finance are aware sexual terms and rules, the following authorities are committed to place a government servant under appointing authority. कौन कौन जो है they can place the following authorities are competent to place a government servant under, वो क्या, वो कौन कौन सी हैं आपकी, वो पता ही है, दैट इज आपकी अपॉइंटमेंट अथॉरिटी. जो भी आपकी अपॉइंटिंग अथॉरिटी है वो कर सकती है. एनी अथॉरिटी टू द अपॉइंटिंग अथॉरिटी सबॉर्डिनेट, अपॉइंटिंग अथॉरिटी जो है सबॉर्डिनेट एनी अथॉरिटी, ठीक है. और फिर बोलता है डिसिप्लिनरी अथॉरिटी, तो बोलता है एनी अथॉरिटी अदर अथॉरिटी empowered on behalf by the president, ठीक है. The supervisory officers in field office located outside the headquarters where necessary be empowered to place officers subordinate to them and assessments to the condition mentioned below by issuing specified in the name of particular in person. यहाँ पर बोलता है ये subject to the condition mentioned in the above by issuing special orders in the name of president in pursuance of rule 10. यहाँ पर क्या है, supervisory officer in the field of the supervisory officer in the field of located outside be empowered to place subordinate to them and assessments to the condition uh, to conditions mentioned in para 2 above by issuing special order in the name of president. So the change of headquarters during suspension क्या आप कर सकते हैं? Yes. An officer under suspension is regarded as subject to all other conditions of service applicable general to government cannot leave the station without permission and cannot leave the station without prior permission. As such, the headquarters of the government servant should normally be assumed to his last place of duty. However, an individual under suspension request for change of headquarters, यहाँ पर जो है where an individual request for change of headquarters, there is no objection. There is no objection to a competent authority. There is no objection to a competent authority changing the headquarter if it is satisfied. अगर जो है वो क्या है, if it is satisfied है, अगर वो if it is satisfied that such change court will not put government to an extra expenditure like granting of traveling losses etc or other complications. The order placing an order of suspension should clearly indicate that headquarters is headquarters. जो भी आप ऑर्डर कर रहे हैं ना इसके अंदर में, ये ऑर्डर जो है ऑर्डर प्लेसिंग अंडर सस्पेंशन जो है should clearly indicate what his headquarter would be, ठीक है. speedy speedy follow up action in suspension case and time limits. Instances have been noticed where inordinate delay has taken place in filing charge sheet in court where prosecution is launched and is serving charge sheet in cases where disciplinary proceedings are arranged. देखिए, it have been noticed where inordinate delay has taken place in charge sheet. देखिए, अगर आपको दो केस है यहाँ पर, वहाँ पर प्रोसिक्यूशन होता है ना, वहाँ पर आपको फाइलिंग चार्ज शीट करनी है कोर्ट्स के अंदर, ठीक है. और जहाँ दूसरा आपका केस है जहाँ पर डिपार्टमेंटल डिसिप्लिन प्रोसीडिंग्स चलनी है ना, वहाँ पर सर्विंग चार्ज शीट. प्रोसिक्यूशन की बात आती है फाइलिंग चार्ज शीट, डिसिप्लिनरी प्रोसीडिंग्स क्या आती है तो सर्विंग चार्ज शीट. तो ये क्या है, रिडोंडेंट डिले हो रही है एक तरीके से, ठीक है. इस डिले के लिए उन्होंने बोला है, इसके लिए क्या बोलते हैं वो, इवन द सस्पेंशन मे नॉट बी कंसीडर्ड एज अ पनिशमेंट, इट डज नॉट, ठीक है, इट इज नॉट अ even though suspension may not be, suspension जो है may not be considered as a punishment. Okay, it does not constitute a very great it does constitute a very great hardship of the government servant. In fairness to him, the period is reduced to the barest minimum. It has therefore decided that in case of officers under suspension, the investigation should be completed with a charge sheet filed in the courts of the competent jurisdiction in case of prosecution or served to the officer in department within 3 months. ये बहुत इंपॉर्टेंट है, विदिन 3 मंथ्स आपको करना है एज अ रूल, एज अ रूल, ठीक है. इफ द इन्वेस्टिगेशन इज लाइकली टू टेक मोर टाइम, अगर मान लीजिए आपको लगता है कि थोड़ा likely to take more time, it should be considered whether the suspension order should be revoked and the officer permitted to review his duty. तो आपको ये चेक करना है, and it should be considered whether the suspension जो है order should be revoked and the officer permitted to resume duty. If the presence of the officer is considered detrimental to the evidence, he may be transferred to revocation. तो उस केस में आप क्या कर सकते हैं, then he may be transferred on revocation of the suspension. ठीक है, ये बहुत इंपॉर्टेंट है यार. अपॉर्चुनिटी टू सस्पेंडेड गवर्नमेंट सर्वेंट्स टू अपील अगेंस्ट सस्पेंशन. The government servant is placed under suspension, he has the right to appeal against the order of suspension. ठीक है, and this would imply that the government servant who is placed under suspension generally know the reasons for the suspension. ठीक है, so this would imply that a government servant who is placed under suspension should generally know the reasons leading to a suspension, that he may be able to make an appeal against. Where a government servant is placed under suspension on the ground that a disciplinary proceeding against him is pending or a case against him, inquiry or trial, the order placing him under suspension would itself contain a mention in this regard that he would therefore be aware of the reasons leading. ठीक है, then he should be aware of the reasons leading to suspension. Where a government servant is placed under suspension on the ground of contemplated proceedings. ठीक है, where a government servant जो है, government servant is placed under suspension on the ground of contemplated discipline proceeding, the existing instruction provide that every effort would be made to finalize the charge. यानी क्या है इस केस में, आपको every effort would be made to finalize the charge against the government servant within 3 months of the date of suspension. These instructions are strictly adhered to the government servant who is placed under suspension on the ground of contemplated proceeding will become aware of the reason for suspension without much loss of time. However, there may be some cases in which it may not be possible. ठीक है, some cases in which it may not be possible for some reason or the other to issue a charge sheet within three months from the date of suspension. Such cases, the reason for suspension should be communicated. बोलता है the reason for suspension should be communicated to the government servant immediately on the expiry of the aforesaid time prescribed for issue charge sheet, so that he may be in a position to effectively exercise the right of appeal. ठीक है, if he so desires, right, where the reason for suspension are communicated on the expiry of the time limit for the time limit for 45 days submission of the appeal should be counted. ठीक है, यहाँ पर एक important ये है ना आपका, where reason for suspension are communicated on the expiry of the time limit prescribed for the issue of the charge sheet. Time limit बोलता है the time limit of 45 days for submission of appeal should be counted from the date on which the reasons for suspension are communicated. ये बहुत important है, it will take 45 days की बात कर रहे हैं. ठीक है, 45 days है आपका. कब से है, should be counted from the date on which the reasons for suspension are communicated. ठीक है, the reason contained in the preceding paragraph will not, however, apply to cases where a government servant is placed under suspension on the ground that he has engaged himself in activity prejudicial. The reason contained in the proceedings in the preceding paragraph will not, however, will not apply cases where a government servant is placed under suspension. ठीक है, on the ground that he has been engaged himself in activities prejudicial to the interest of the security of the state. ये जो वाले जो है ये नहीं एप्लीकेबल. Important. The decision contained in the preceding paragraph, पहले वाले में से is understood on the ground of contempt मैंने कहा इस तरीके से अगर सिक्योरिटी इंटरेस्ट ऑफ सिक्योरिटी ऑफ स्टेट है तो ये एप्लीकेबल नहीं होगा, विल नॉट अप्लाई टू केसेस. ठीक है, जनरल सिविल सर्विसेज क्लासिफिकेशन सीसीए रूल्स बोलता है इंस्ट्रक्शंस रिगार्डिंग टाइम इशू ऑफ चार्ज शीट. इट इज टू रेफर डीबॉडी ऑन नंबर रिगार्डिंग दिस. बोलता है वी देयरफॉर दैट द करेंसी ऑफ सस्पेंशन ऑर्डर शुड नॉट बी ऑन, जो है जो करेंसी ऑफ सस्पेंशन ऑर्डर शुड नॉट एक्सटेंड बियॉन्ड 3 मंथ जाना चाहिए. if within this period the memorandum of charges sheet is not served in the, ठीक है, that the currency of suspension should not extend beyond 3 months if within this period the memorandum of charges not served on the delinquent officer employee. The currency of suspension order not extend beyond 3 months if within this period the memorandum of charge sheet is not served. मतलब चार्ज शीट अगर सर्व नहीं की तो तब भी 3 महीने से ऊपर नहीं जाना चाहिए. इट्स noted that in many cases charge sheets are not issued despite clear prima facie evidence of the many cases जो है ना, it has been in many cases charge sheets are not issued quite clear prima facie evidence of misconduct on the ground that matter is under by an organization like CBI, ठीक है, conduct okay on the ground the matter है, the matter is under investigation like CBI by CBI, ठीक है, in the fourth judgment the super the direction of CBI that pending a criminal investigation department are to be held, ठीक है, that proceeded the direction of the Central Commission that pending criminal investigation department proceedings are to be held in a order which contained the guidelines for timely issue of charge sheet to be and to say that these instructions laid down inter alia where a government servant is placed under suspension on the ground of contempt and disciplinary proceedings. This instruction provide that every effort should be made to finalize the charge sheet against the government within 3 months. ठीक है, तो आपको every effort करना है finalize that within a period of 3 months date of suspension. If these instructions are strictly adhered to, a government servant who is placed in suspension on the ground will become aware of the reason and without much loss of time. The reason for suspension should be communicated to the government servant concerned early so that he may be in a position to effectively exercise the right of appeal available to him under rule this under rule 23I. The limit of 45 days of submission and for submission of appeal should be counted from the date on which the reason for suspension are communicated. Bring the in compliance with the above judgment, refer 1. But it has been decided that where a government servant is placed under the order should not extend beyond 3 months. If in this case the charge sheet is not served to the government servant, as such, it should be ensured that the charge sheet is issued within before expiry of 90 days. Okay? From the date of suspension, as the suspension will lapse in case this time limit is not adhered to. So suspension will lapse. As the suspension will lapse in case this time limit is not adhered to. A close portion needs to be kept on level to ensure that charge sheets are issued in time. It is there to ensure that disciplinary are initiated as far as practical in case where investigation is on the matter or criminal have been launched. ठीक है. For the issue of second suspension order on a fresh charge while under ये कर सकते हैं representative to prescribe certain forms of forms to be issued while issuing orders placing government it is come to know that these forms have been more or less mechanically followed by the various authorities without suitably modifying or adapting them to suit the requirements whenever required. Notice that when the government was placed from defense was under trial against him, there were also certain other contemplation as well cases which are taken into the order of the government in which it only still whereas a case against in the of the office under trial, limiting the suspension only to the criminal case under trial. As a result of this, it happened that when the particular criminal case resulted in acquittal of the question of regulating it was found that the period has to be regulated only on the basis of the outcome of that criminal case, which was referred to. Okay? On the period had to be regulated only on the basis of the outcome of that criminal case, which was referred to in order of suspension. The one which was under trial at the time of issue of order ended in his acquittal and regulation of the suspension could not be based on the other cases, which though taken into account they were at the time of placing him in order of suspension. Thus, even though the departmental case जो है court case which were under contemplation time, even though thus even though the other departmental court cases which were under contemplation investigation at the time of government was placed under suspension not did end or could have ended or in being on being convicted or punished, the period of his suspension had to be regulated only in the light of a period of a suspension had to be regulated in the light of a specific cases referred to in the order of suspension, which ended in acquittal. Although the competent authority desired to take the results of the other cases, the government desired to take the results of other cases also into account. Okay, this this was not possible in view of specific wordings of the order of suspension as referred to a criminal case under trial. However, such declared whether two standard forms are not found fully to meet the requirement of any case, then the competent authority should amplify, modify the appropriate form should meet the requirement of the case and should get the all should indicate that all the cases criminal department trial and termination on the basis of which it is necessary to place the government servant under suspension, so that in the event of reinstatement of a government servant, the outcome of such cases can be taken into account by the independent institution 5 of the case. It is required that if during the course of suspension, government servant, whether in connection with any disciplinary provision or with any commenced against him बोलता है यहाँ पर rule 10(5) भी बोलता है that if during the course of the office of government servant whether in connection with the disciplinary proceedings or otherwise any disciplinary authority proceedings commenced against him, the authority competent to place under suspension for reasons to be recalled in line that may direct the government servant shall continue to be under suspension until the termination of all or any such proceeding. Therefore, whenever an official is under suspension or any other case is initiated against him, therefore, whenever an official is under suspension and the other cases are initiated against him, the concerned authority considers it necessary that the official should remain under suspension. Okay. In connection with that case also, that the competent authority should pass another order. They should pass another order to this effect in accordance with the rule, so that in the event of reinstatement of the gun, the effects of the latter is be also taken into account prior to the period of suspension. Okay. Acceptance of registration of resignation while under suspension. क्या ले सकते हो आप resignation? No, whereas government servant who is under suspension submits the resume, the government authority should examine with reference to the merit of the resume case pending against the government servant whether it would be in the public interest to accept his resignation. आपको यही चेक करना है बस whether it would be in the public interest to accept his resignation. Normally, a government servant in case of grievance, it would not be correct to accept the resignation from a government servant under suspension. Exceptions to this would be where the eligible do not involve. Exceptions क्या है इसके अंदर? Exceptions to the rule would be where the alleged जो है offenses do not involve moral turpitude and where the quantum of evidence against the accused government servant is not strong enough to justify the assumption that the department will continue and he would be removed or dismissed from service where the department are likely to be so that it would be cheaper to the public sector to accept the resignation. ठीक है, तो कर सकता है, फिर उस केस में हो जाएगा. ठीक है, different person so that it would cheaper to the resignation. ठीक है, those cases where acceptance of resignation is considered necessary in the public interest, the resignation may be accepted with the prior approval of the head of the department. ठीक है, where is it considered necessary in the public interest? In the public interest, the resignation may be accepted. The resignation that may be accepted with the prior approval of head of department in respect of Group C or Group D cases, post and that of the minister in charge in the case of मिनिस्टर के कब लेना इन द ग्रुप ऑफ ग्रुप ए और ग्रुप बी के लिए. insofar as group officer 7 in order के वही बोलता है insofar as ग्रुप बी ऑफिसर. ठीक है, किसी और से बोलता है ग्रुप बी ऑफिसर से बात करते हैं सर्विंग इन इंडियन ऑडिट एंड अकाउंट डिपार्टमेंट कंसर्न द रेजिग्नेशन ऑफ सच ऑफिसर shall not be accepted. Resignation जो shall not be accepted except will not be accepted except with the prior approval of the CAG. The concurrence of CVC should be obtained before a case to the minister in charge. और इसके अंदर एक और बात इन्होंने बोल दिया, और जो है concurrence जो है of the CVC commission should be obtained before submission of the case to the minister in charge. Okay, if the CVC advise initiation of department action against the concern of such resignation and advice किस केस में करना है आपको? If the CVC had advised initiation of department action against the government servant concerned or such a resignation becomes effective when it is accepted by the government and is the duty of the government servant who has submitted the resignation sends an intimation. If the government servant he just sends an intimation writing to the appointing authority withdrawing his earlier letter of resignation before its acceptance by the opponent, the resignation seemed to have been automatically withdrawn. तो क्या होगा? That the resignation will be have been automatically withdrawn and there is no question of accepting the resignation. In case, however, in case writing the point of withdrawing the earlier letter for is withdrawn and there is no reason. In case, however, the resignation has been accepted, जो है resignation जो है that had been accepted कर लिया by the appointing authority and the government servant will be relieved from the future date. The government servant is to be relieved from a future date. ठीक है, if any request for withdrawing or withdraw the resignation made to the government servant before the actual relief of his duties, the normal principle should allow the request government to withdraw the resignation. The normal principle जो है should be allowed to request However, the request for withdrawal is to be refused. If, however, the request for withdrawal is to be refused, the grounds for rejection, the request should be clearly recalled by the appointing authority and suitably intimate concern. Voluntary retirement resignation. लोग जो है वॉलंटरी रिटायर हो रहे हैं, ये रिजाइन कर रहे हैं. नोटिस ऑफ वॉलंटरी रिटायरमेंट नंबर 1 and not for it is open to the appropriate to hold permission to a government servant there under either of these rules. तो कर सकते हैं आप इसमें क्या कर सकते हैं, under 6 government servant hold, they can withhold the permission. Not open, it's open to the administrative authority to withhold permission. बंदा वीएस लेना चाहे, रिजाइन करना चाहता, बोलता है on notice of voluntary retirement given after completion of 20 years qualifying service will require acceptance by the appointing authority. The date of retirement on the expiry of notice would be earlier than the date of which the government servant would have retired voluntarily in the existing notice of voluntary retirement given after completion of 20 years. देखिए अगर आप कोई भी आप एक वॉलंटरी रिटायरमेंट का कभी देते हैं ना, नोटिस ऑफ वॉलंटरी रिटायरमेंट गिवन आफ्टर completion 20 years qualifying service will require acceptance by the appointing authority. By the appointing authority if the date of retirement on the expiry of the notice would be earlier. The date of retirement on the expiry of the date of retirement, the date of retirement on the expiry of notice would be earlier than the date which the person could have retired voluntarily. The date of retirement on the expiry of the notice given after completion of 20 years qualifying service will require acceptance by the if the date of retirement of the expiry of the notice would be earlier if the notice would be earlier than the date of early to him. Exception may generally be given all cases except generally given a notice of voluntary retirement. A notice of voluntary retirement completion 20 years. Notice of voluntary retirement after 20 after years qualifying service will require acceptance of by the date of retirement of the earlier than the date of retirement on the expiry of the notice will be earlier than the date on which the if the date of retirement on the expiry of the notice here, the date of retirement on the expiry of the notice retire voluntarily will be in all cases kept कहता है फर्स्ट वाला बोलता है maybe the decision proceedings are pending on 7 which except in which the decision pending or contemplated against the government servant and in the penalty authority having regard to the cases of the case. ठीक है, जहाँ पर दूसरा बोलता है in with the prosecution or may have been court of law अगर prosecution ठीक है notice requirement when in such case approval of minister in the is proposed to accept the notice of voluntary retirement even if approval of minister in charge should be obtained regard of group and group. ठीक है, ग्रुप ए तो ग्रुप मिनिस्टर आपका अप्रूवल रिटायरमेंट. ठीक है, and government servant and head of the department to be by the head of the department. In the case of Group C, Group D department. Even where the notice of retirement given by government was accepted by the appointed authority, government may presume acceptance and retirement shall be effective in terms of unless the government is in order for the expiry period of notice. ये बहुत इंपॉर्टेंट है, ठीक है। बोलता है even where the notice of voluntary retirement given by government requires acceptance, even where the notice of the voluntary given by the notice है ना voluntary retirement का जो notice है भाई requires acceptance by the appointing authority, the government servant giving notice presume ये क्या है कि जो गवर्नमेंट सर्वेंट है ना he may presume acceptance, may presume the requirement shall be effective in terms of unless shall be effective in terms of the notice unless the competent authority is in order to the contrary before the expiry of this, unless competent authority issues an order to the, for the expiry of the period of notice. Legal to compel an employee under suspension of employee under suspension of has been held that during the suspension illegal है भाई। The regulation of suspension dependency of regulation of suspension during pendency and the cases of suspension pendency of proceeding for arrest or debt or during detention, ये important है। क्या कहता है आपको? In the cases of suspension during pendency of criminal proceedings का है या फिर proceedings for arrest है या फिर for debt है और during detention जो है under a law providing for preventive detention will be dealt with in the following manner. A government servant who is detained in custody under any law providing for preventive detention, who is detained in custody, okay, under any law providing for preventive detention, or as a result of proceeding either of or as a result of the on charges or is arrest for debt shall, if period of detention exceeds 40 hours, 40 hours, and unless he is already under suspension, okay? And unless he is suspension be deemed to be under suspension period of detention until further orders as contained in Rule 2. Government servant who is undergoing a sentence of imprisonment shall also be dealt with the same manner pending decision on the decision taken against going a sentence shall also be dealt with the same manner pending decision the disciplinary action be taken against. But the government servant against whom a proceeding has been taken on a charge but who is not actually due to custody, yeah, उसका भी ये person bail मान लीजिए a person जो है he is placed under may be placed under suspension by government. If the charge is connected with the official position of the government servant, the charge जो है connected with the official position of government servant perpetued down if there are exceptions. The suspension will be there are exceptions. Oral trip in the yes, exception rule. Government servant against whom a proceeding has been taken for debt, which who is not actually detained in custody but may be placed on. Okay. The proceedings चल गई आपके पास for the government servant against proceedings. The proceedings Sergey has been taken for arrest for debt. He is no, but he is not actually detained in custody. Not actually detained in custody. Patient by an order. This patient is contemplated. Issue this. Is only if the decision is contemplated. If the तभी आपको ये करना है. चलिए आगे चलते हैं. Withholding of permission to retire when placed under suspension after receipt of notice. Withholding of permission to retire when placed under suspension after receipt of notice. बोलता है for the attached is to provide this wherein it is provided that it shall be open to the it shall be provided that it shall be open to the appropriate authority to withhold permission to a government servant under suspension. Permission to a suspension who seeks to retire. A question has been raised whether whether question has been raised whether the right conferred on the appropriate authority under this process can be exercised by the representative respect of a government servant who is he has given the notice of retirement. The question has been clarified that the right to confer the right conferred on the appropriate authority above process can be exercised by the authority even if government servant for giving notice of, but the right shall be exercised by the said authority after the expiry of, but such right shall be exercised by the said authority after the expiry of the period the notice given by the withholding of permission to retire when placed under suspension after receipt of notice. ठीक है. It was the providing of application for other posts. Providing of forwarding of application for other posts नहीं कर सकता भाई principal regarding question बोलता है to UPSC from candidate serving under the government has been reviewed. ठीक है. It has been decided to consider the instruction the subject therefore अब ये क्या कुछ इंस्ट्रक्शन दे रखे एप्लीकेशन जो है of a government servant for appointment whether by direct recruitment transfer or deputation to any other post should not be considered forward if he is under suspension. देखिए बहुत इंपॉर्टेंट है. Application of a government servant for appointment. Application for a government servant for appointment whether by direct recruitment, transfer, deputation or transfer to any other post should not be considered. Should not be considered. If क्या कहता है if he is under suspension, disciplinary proceedings are pending, ठीक है, and sanction for prosecution where necessary accorded in accordance by the commitment authority. Where prosecution sanction is not necessary, a charge sheet has been filed for criminal prosecution. ठीक है. Well, when the content of is undertaken by the CBI or the content department, but the investigation has not reached the stage of issue of charge sheet or prosecution sanction or filing of charge sheet for criminal prosecution in court, the application देखिए अब यहाँ पर तीन चीज़ दिया आपका but the investigation has not reached the stage of issue of charge sheet. ठीक है. आप चार्ज शीट इशू करते हैं ना, किस केस में करते हैं चार्ज शीट इशू, जहाँ पर आपको जब करना होता है कोई डिटेंशन वगैरह हो गया है ना, इशू ऑफ चार्ज शीट. ठीक है. और प्रोसिक्यूशन सैंक्शन और या फिर प्रोसिक्यूशन कोई सैंक्शन ऑफ फिलिंग ऑफ चार्ज फाइलिंग ऑफ चार्ज शीट फॉर क्रिमिनल प्रोसिक्यूशन for the application of such a government servant may be forwarded together with brief comments on the application of such a government may be forwarded together with the brief comments on the nature of allegations. It should be made clear that in the event of action the government he would not be released for taking the appointment that charge sheet for imposition of penalty. Yes, कहता है when the conduct of a government servant is under investigation CBI but the investigation has not reached the stage of charge sheet जब इन्वेस्टिगेशन जो है ना हैज़ नॉट रीच द स्टेज ऑफ इशू ऑफ चार्जशीट, ठीक है, और प्रोसिक्यूशन सैंक्शन और filing of a charge sheet for criminal prosecution in a court, the application of such government may be forwarded, जो है दी एप्लीकेशन जो है ना उसकी ऑफ सच गवर्नमेंट मे बी फॉरवर्डेड, उसको आप कर सकते हो, मे बी फॉरवर्डेड टुगेदर with brief comments, with brief comments on the nature of allegations, and it should be also made clear that in the event of clear that in the event of actual selection of the government servant, he would not be released for taking up the appointment if that if the time charge sheet for imposition of penalty, if by the time charge sheet for imposition of penalty for sanction issued in a charge sheet is filed in the court of revenue, and if he is placed in, or he is placed under suspension, ठीक है. Where government servants apply directly to UPSC, as in the case of direct recruitment, they must immediately inform the head of their office department, giving details of the examination post for which they have applied, requesting the permission to the commission directly. If, however, the head of the department considers it necessary to withhold the requisite permission, should inform the commission accordingly within 45 days of the date of closing receipt application. ठीक है. Where government servant apply directly, the government servants हैं, they apply directly to UPSC. ठीक है. As in the case of direct recruitment, they must immediately inform the head of their office. So they must inform the head of their office department, giving details of the examination, ठीक है, post for which they have applied, requesting him to communicate his permission to the commission directly. Okay. If, however, the head of the department considers it necessary to withhold the requisite permission, if, however, the head of his office considers it necessary to withhold the requisite permission, he should inform the commission. Good. Then he should inform the commission accordingly within 45 days of the in case any situation mentioned in para 3 is obtaining, the requisite permission should not be granted, and UPSC should be informed accordingly. In case the situation mentioned in para 4 is obtaining, action may be taken to inform UPSC of this fact, and also the nature of allegation against the government servant should be also clear that the event of action selection of the government should not be relieved of taking the charge of action is issued in charge sheet is filed in the court of the government. ठीक है, ये बताना है आपको that made clear that in the event of actual selection of government servant, he would not be relieved for taking the appointment if the charge sheet prosecution of the charge sheet filed in the court of or इससे ठीक है. The Administration Department of may also note that in the case of direct by selection by interview, it is the Recreation Ministry Department to bring the notice to the Commission any point regarding unscheduled the candidate government servant from vigilance angle, and that the appropriate stage for doing so would be the consultation at the time of preliminary scrutiny, and the case is referred by the Commission to the Ministry or Department for the comments of Ministry representatives on the provisional selection of the candidates for interview by the Commission. The promotion, confirmation of orders under suspension or against whom disciplinary pending. Promotion और confirmation. Promotion हाँ वो भी कर सकते हैं, confirmation भी कर सकते हैं. ठीक है, चलिए कुछ बताया था हमने, क्या बताया ये देख लीजिए. वही जो यहाँ पे ये डाइजेस्ट के अंदर तो काफ़ी कुछ हो गया है. बेसिकली रिविजन ऑफ दिस ये कि इफ वी डू सो विल हैव विल बी डबल कॉन्फिडेंट. तो भी कर लिया और जनरल ऑर्डर्स को भी कर लिया. ठीक है, कहीं ना कहीं यस दिस विल हेल्प अस. मुझे लगता है कि ये कहीं ना कहीं थोड़ा सा बेनिफिशियल भी है. आपको काफ़ी सारी चीज़ें जो है इसके अंदर मिल रही है रिलेटेड टू सस्पेंशन, और ये कहीं ना कहीं हमारी हेल्प भी करेगी जब व्हेन वी विल बी रीडिंग दिस, हमारा जब हम ये करेंगे ना अपना. ओके, तो हम बात कर रहे थे प्रमोशन और कंफर्मेशन ऑफ ऑफिस ऑफिस ऑर्डर अंडर सस्पेंशन और अगेंस्ट डिसिप्लिन आर पेंडिंग. ठीक है, The procedure and guidelines to be followed in the matter of promotion of government servants against whom reports are pending or whose conduct is under have been reviewed carefully. ठीक है, as a result of the review of suspension in supervision of all their instructions. क्या क्या बताता है, cases to whom sealed cover procedure applicable at the time of consideration of the case of promotion, details of government servant consideration for promotion falling under the this specifically brought to the notice of the department. ठीक है, तो cases to whom sealed cover procedure applicable. ठीक है, in consideration zone falling under the brought to the notice of the DPC. क्या कि भाई कौन सा गवर्नमेंट सर्वेंट है जो अंडर सस्पेंशन है, पहली चीज़ रिस्पेक्ट ऑफ होम डिसिप्लिनरी प्रोसीडिंग्स आर पेंडिंग, दूसरा है आपका होम प्रोसिक्यूशन ऑफ क्रिमिनल चार्जेस इज पेंडिंग, पॉजिटिव फॉलो रिस्पेक्ट ऑफ दिस रोज अंडर क्लाउड। क्या बोलता है, डीपीसी शैल असेस द सूटेबिलिटी ऑफ द गवर्नमेंट सर्वेंट कमिंग विद द प्रीव्यू ऑफ द सर्कमस्टेंसेस मेंशन्ड अबव अलोंग विद अदर एलिजिबल कैंडिडेट्स। ठीक है, ठीक है, उनको देखिएगा मेंशन अबव without taking into consideration the, this is important, that without taking into consideration the discipline case or criminal proceeding, that the assessment of the DPC including that is including the assessment जो भी होगी ना उनकी of the DPC including unfit for promotion and the grading awarded by it will be kept in a sealed cover. The cover will be superscribed findings regarding suitability for promotion of the grade of this is not to be open till the termination of the discipline. ठीक है, the proceeding of the DPC should not in the note the proceedings of the DPC. In the note, the findings are contained in the attached seal cover. ठीक है, the authority competent to fill the vacancy should be separately. The authority competent to fill the vacancy should be separately advised to fill the vacancy in the higher grade only in an officiating capacity when the findings of DPC is sealed cover. ये important है आपका ये, that the authority competent to fill the vacancy should be separately advised. आप अलग से separate fill the vacancy in the higher grade only. ठीक है, in an officiating capacity when the findings of the DPC in respect of suitable to the government servant for his promotion are kept in a sealed cover. Not applicable to review DPC. The question whether the sealed cover procedure to be followed in the case of review DPC has been under consideration of the in the light of then the sealed cover procedure as contained in the OM cannot be resorted to review DPC. तो सील्ड कवर जो है प्रोसीजर जो है एज कंटेन्ड इन द OM cannot be resorted to by the review DPC if no department proceedings or proceedings जो है was pending against the government servant. The sealed cover procedure जो है cannot be resorted to by the review DPC if no department, ठीक है, if he was not under suspension at the time of meeting of original DPC or before, or he was not under suspension, ठीक है, or before promotion in his junior or before promotion of his junior on the basis of recommendation of the original DPC. The matter has been in consultation with the Ministry of Law and sealed cover procedure जो है as contained in the OM. This cannot be resorted to by the review DPC if no department proceedings or was pending against him against the government servant or he has not been under suspension or he had or she was not under suspension at the time of meeting of original DPC or क्या कहता है or before promotion is junior on the basis of the recommendations of the original DPC. सील्ड कवर प्रोसीजर जो आपको फॉलो नहीं करना है बिफोर promotion is junior promotion of junior on the basis of recommendation of original. Procedure by subsequent DPC. Same procedure outlined in the para 2.1 will be followed by subsequent DPC committee convened till the disciplinary concerned is concluded. Action after completion of disciplinary on conclusion of अगर मान लीजिए जो भी आपका है और on conclusion of the disciplinary case, जैसे आपका disciplinary case जो है conclude हो गया, ठीक है, on the conclusion of the disciplinary criminal prosecution or investigation which results in dropping of allegations, ठीक है, और complaints against the government servant has shield cover जो है shall be opened in case the government servant is completely exonerated. अगर मान लीजिए वो completely exonerated है, the due date for his promotion will be determined due date of his promotion जो है will be determined with reference to the position assigned to him in the findings kept in sealed cover, ठीक है, with reference to the date of promotion of his next junior, with reference to the date of promotion of his next junior, on the basis of such promotion such position the government servant may be promoted if necessary by reverting the junior most official. ये बहुत इंपॉर्टेंट है that the government servant जो है may be promoted if necessary by reverting the junior most official person. He may be promoted notionally with reference to the date of promotion to junior, ठीक है. सर कहता है क्या कहता है that he may be promoted notionally with reference to the date of promotion of his junior. However, whether the officer concerned will be entitled to any arrears, वो जो है arrears वगैरह के बारे में अगर हम बात करें तो he will be entitled to any arrears for the period of notional promotion preceding the date of actual promotion. What action will be decided by the appointing authority. Appointing authority by taking into account all facts and the authority denies areas of self appointing. तो अगर वो deny करता है, but denies areas, so he will record reasons for doing so. It is not possible to anticipate or enumerate exhaustively all circumstances under such denials of areas. However, there may be cases where the proceedings or are example delayed for the instance of the apply or the clearance in the discipline put in the without with benefit of doubt or account of non-availability of evidence due to the acts attributable to the employee. These are only some of the such. But that is not possible to. However, there may be cases with the where disciplinary or criminal are where whether disciplinary or criminal are, for example, delayed at the instance of the employee. Okay, or the clearance in the disciplinary or equivalent benefit of doubt. Whether disciplinary or criminal cases they are example delayed of the or the clearance in the disciplinary or equivalent in the criminal doubt or on account of non evidence. आप मना कर सकते हो, ठीक है. If any penalty is imposed by the government servant as a result of disciplinary proceedings is found guilty in the criminal proceeding, the findings of the field cover shall not be acted upon. His case for promotion may be considered by the next DPC in the normal course. अगर मान लीजिए वो जो है if penalty is imposed on the government servant as a result of discipline penalty लगाई गई अपने disciplinary proceeding में, ठीक है, found guilty, तो the findings of the field cover जो shall not be acted upon, ठीक है, और his case of promotion जो है इस केस में may be considered by the next GP in the normal course having regard to the penalty imposed. Okay? It is also clarified that where the disciplinary proceedings have been held under the relevant disciplinary rules, warning should not be issued. The result of then clarified that where disciplinary proceedings have held and the warning should not the result of that should some blame attached to this जो है censure should be imposed. Okay? Where disciplinary proceedings this censure should be imposed. Warning should not be issued. 6-month monthly review of the field cover case. It is necessary to ensure that the disciplinary case, criminal prosecution investigation instituted against the government servant is not unduly prolonged. All efforts to finalize the proceeding should be taken so that the need for keeping the cases of government servant in field cover is limited to the barest minimum. It therefore has been decided that the appointing authority concerned should review the appointing authority concerned should review comprehensively the cases of government servant whose suitability for promotion to a higher grade has been kept in a sealed cover. The expiry of 6 months. The appointing authority concerned should review comprehensively the cases of government servant whose suitability for promotion to a higher has been kept in a sealed cover on the expiry of 6 months from the date of convening of first department committee. Okay. Which had and kept its finding in a sealed cover. The review should be done also every 6 months. The review should entirely cover the progress made in the disciplinary proceedings, criminal proceeding, and the further measures to be taken to their completion. Procedure for ad hoc promotion. Ad hoc promotion दे सकते हैं. 5 to 6 monthly review of where the disciplinary case investigation, criminal prosecution, the government servant are not included. Period of 2 years. ठीक है. जहाँ पर जो इन्वेस्टिगेशन जो है ये सब केस, ठीक है, दे आर नॉट कंक्लूडेड after expiry of 2 years from the date of meeting, which kept its finding in the respect of the government and appointing authority may review the case of the case, and he is provided he is not under suspension to consider the desirability of giving a document. यहाँ पे लिखा है provided he is not under suspension, उस केस में to consider his case, to consider the desirability of giving him a promotion to the following. Whether the promotion is against public interest, promotion likelihood of in finalization of कुछ अपनी चीज़ें देखनी एक तरीके से कि अगेंस्ट पब्लिक इंटरेस्ट में है या फिर इन वारंट चार्जेस आर ग्रेव, चार्जेस जो हैं दे आर ग्रेव इनफ टू वारंट कंटिन्यूड डिनायल ऑफ प्रमोशन, likelihood case coming to a conclusion in is coming to a conclusion in near future, whether the delay in the finalization of department of control not directly or indirectly attributable to the government servant, the likelihood of misuse of position may occupy after a promotion check which may adversely affect the conduct of the departmental case. The appointment committee should also consult the CBI जो है and take its reviews and upon the department proceeding was out of their investigation by the bureau. In case of appointing authority comes to that it would not be against the public interest to allow a promotion, it should be placed before the next DPC. In case जो है in case the appointing authority comes to a conclusion that it would not be against the public interest to allow a promotion before the next DPC held in the normal course. ठीक है, the expiry of 2 periods. After the expiry of 2 years period to decide whether the officer is suitable. The government service is considered for under promotion. The department committee should make its assessment on the basis of totality of individual report. ये कहता है whether the officer should get the government service considered under promotion. The government DPC जो है DPC should make its assessment on the basis of the totality of the individual report of service without taking into consideration the benefit against it. After decision is taken to promote on an basis, order promotion may be issued clear. The promotion is being made on purely ad hoc basis, and the promotion will not confer any right to regular promotion. The promotion shall be until further orders है. Promotion जो है until further orders should also the right to cancel. The government has that reserve the right to cancel the ad hoc promotion and revert at any time the government servant to post from which he was promoted. The government servant जो है concerned is acquitted in the criminal prosecution. मान लीजिए कोई भी गवर्नमेंट सर्वेंट है इज एक्विटेड और उसको बरी कर दिया जाता है, ठीक है, एक्विटेड इन दी the criminal prosecution merits of the case and is fully exonerated, उसको fully exonerate करना in departmental proceedings में. The ad hoc promotion will be made by the confirmed be treated as regular. तो ad hoc promotion जो अपन दे रखे हैं may be treated, may be confirmed and treated as a regular one on the date of ad hoc promotion with all attendance benefits. In case the government servant could have normally got his regular promotion ad hoc promotion, ठीक है, with reference to his placement in the DP captain sealed cover and the actual date of promotion of the person ranked immediately junior to him, and the actual date of promotion of the person ranked immediately junior to him by the same DPC would be allowed to do due seniority, और उनको जो है be allowed due seniority and benefit of promotion. Okay? If the government servant is not acquitted on merits of the purely on technical, ये बात करते हैं जो the government servant is not acquitted on merits but purely on technical grounds and government either proposes to take up a charge. The government जो है either proposes to take up the matter to a higher court or proceed against him. Okay? Government is not exonerated in the department proceeding, or if the government servant is not exonerated in the department proceeding, a document grant to him should be brought to an end. Okay, तो ad hoc promotion जो है should be granted to him, should be brought to an end. तो वापस लगा brought to an end. Field cover procedure for confirmation. The procedure outlined the preceding para should also be followed in considering the claim for confirmation of permanent vacancy should be reserved for such an office when this case is under सेम फॉर परमानेंट वैकेंसी, वो कहता है परमानेंट वैकेंसी है शुड बी रिजर्व फॉर एन ऑफिसर which the case represented by the DPC. Okay. Officers coming under cloud after DPC meeting. Permanent vacancy, चलिए ठीक है. Officers coming under cloud after DPC meeting. DPC की मीटिंग होगी उसके बाद जो है हमारा गवर्नमेंट से रिकमेंड by the DPC, but in case any of the circumstances mentioned in para 2 above are arise after the, ठीक है. अगर कोई ऐसा आ गया उस केस में आप क्या करेंगे? They are received but they but before he is actually promoted, ठीक है. तो जो है गवर्नमेंट सर्वेंट recommended for promotion in case of any of the rise, ठीक है. Will be considered as if his case had been placed in a sealed. He will be considered as if his case had been placed by the DPC. Will not be promoted until he completely exonerate on the charges, ठीक है. फिर कहता है that he shall not be promoted until he is completely exonerate on the charges against him and the proven content. बोलता है in case of Delhi jail board remand, the right to be considered by the department committee, the fundamental right guaranteed under Article 6 of the Constitution, provided the person is eligible and is in the zone of procedure. The sealed procedure permits the question of promotion to be kept in abeyance till the result of any pending, but the findings of the would have to be given effect as they obviously relate back to the date on which the charges are. The mere fact that by the time the proceeding the first inquiry ended in his favor, and by the time the seal was opened to give effect to it, and the department inquiry was started by the department, would not come in the way of giving him the benefit of the assessment. The first department only in favor of the anterior selection. It is therefore clarified that it will not be possible it by the time seal was open to give effect. ये कहता है कि it is therefore clarified that para 7 this will not be applicable if by the time the seal was open to give effect to the exoneration in the first inquiry, another department inquiry was started by the department, and another department inquiry was started by the department against the government person. This means that where the second or subsequent department proceedings were after promotion of the junior of the department, then on the basis of division after the government servant, benefit of assessment by the first division basically to the government servant. First inquiry by the fifth is further clarified that in case the subsequent proceedings after the promotion of the junior result in imposition of any penalty before the exam, recommended division or captain field covered, and the government servant concerned is promoted on the day of the imposed may be modified and affected with reference to post. An indication to this may be made in the provision of officer under suspension. Officer under suspension shall be considered by the DPC along with the others. However, the recommendation presidency is open not suspended DPC, but before he is actually promoted, going to have been placed in the sealed cover. ठीक है, ये important है. An officer is suspended subsequent to the meeting, but before he is actually promoted, been placed in the sealed cover. When promotion comes up and consideration during pendency of the confirmation, when promotion comes up for consideration during pendency of confirmation proceedings. Yes, certain cases have arisen where the question of promotion of an officer against whom disciplinary have been initiated. Where the question of promotion of an officer against whom have been initiated or condemned has come from before the conclusion of the proceeding, and in whose case the confirmation doesn't have been kept in a cover. This type of case is very rare and may not warrant issue of general instruction. However, this matter has been considered important. In a type of cases referred to above, the name of such an officer may not be included in the name of such an officer may not be in this list of the grade, but a footnote may, however, be given list to the effect that this person in the list will be determined on the conclusion of the department. Yes, but a footnote जो आप दे सकते हैं may begin that तरीके से जो है will be the conclusion of the department against him on the implementation of the findings of which considered his fitness. Cases where before the discipline proceedings then end. The question will also come up before that the findings of the DPC whether the official found fit or is that he is found fit, then the can be considered the reference in the seniority test based on his fitness for confirmation. Thereafter, finding into his in place in cover again along with that of confirmation. In case he has been found fit, then the officer's suitability for promotion can be considered with reference to the position in the seniority list. Based on his fitness for thereafter the findings relating to his promotion again placed in the cover along with that of confirmation. The officer is exempt the findings with regard to both confirmation and promotion. In case he has been found fit, can be implemented without any difficulty. Okay. Based on his fitness for confirmation and thereafter the findings related to his promotion again based on the sealed cover along with the confirmation. ठीक है और बोलता है if eventually the officer exonerated the findings with regard to both confirmation and promotion case can also be implemented without any difficulty. On the other hand, if he is not confident but at the same time he has been found fit for confirmation, no question of the confirm. बहुत important है यार ये point बहुत important है that if he is not exonerated but in the same time he has been found fit for confirmation or promotion, there is no question of being either confirmed or promoted. Similarly, if the DPC has found unfit, अगर DPC जो है उसको similarly if the DPC has found him unfit for promotion, the DPC has found him unfit for promotion irrespective of whether he is exonerated or not, cannot be promoted. But there will be no objection of his being confirmed if he is exonerated. बात करते हैं where an opening of the sealed cover letter confirmation is found that DPC has found the person unfit for confirmation. Okay? Then, irrespective of whether he is ignorant or not, he cannot be confirmed in his term on the conclusion of the discipline process. It would necessarily have therefore to lose seniority. Therefore, in such case, the DPC, which considers his case for promotion, would have to see whether, having regard to the position in the seniority list below or confirmed with the zone of consideration and consider his zones for promotion if he is within the zone. Thus, in cases where it is found that it is in the zone of consideration, then finding with regard to his promotion can be kept in the cover based on finding given when the seniority position available to him. After taking into account his if, however, the person concerned goes outside the zone of consideration, it will be for confirmation. If, however, the person concerned goes outside the zone of consideration due to ineligibility for the confirmation, then this assessment will know that this aspect itself may be noted and kept in a sealed cover so that to ensure that person does not come to know the outcome of the findings of the division. Eventually, when the disciplinary proceedings are over, the fact that he was ineligible for confirmation on the basis of DPC or the fact that he could therefore not be considered for second DPC purpose of confirmation outside of zone of consideration made known. In certain cases, other cases which are not covered by the portion, or depending on facts of the case, there will be no other alternative but to hold review DPC both for the officer confirmation. Fixation of seniority in case of suspension within where minimum service could not be put up in. A question has been raised as how the seniority should be fixed in a case of where for promotion next higher grade a minimum period of employee consumption could not be up on account of suspension could not be up in okay for promotion there's a minimum period of service is prescribed but which the government service concerned could not put in on account of his suspension which was ultimately found to be wholly unjustified. Yeah, so okay. Okay. And बोलते fixation of seniority in case of suspension, exoneration, and promotion where minimum prescribed service could not be put in and due suspension. Fixation of seniority in case of suspension, exoneration, and promotion where prescribed service could not be put in due suspension. Yeah, I think I need a break. Just give me 5 minutes. I'll be back in 5 minutes. right? Yes, here we are. अभी हम स्टार्ट करते हैं. दैट इज फिक्सेशन ऑफ सीनियोरिटी इन केस ऑफ सस्पेंशन, एक्सोनरेशन एंड प्रमोशन वेयर प्रिस्क्राइब्ड सर्विस कुड नॉट बी पुट इन ड्यू टू सस्पेंशन. ठीक है. A question has been raised like how the seniority should be fixed in cases of above type where where for promotion for the next higher grade a minimum period of service is prescribed but which the government servant could not put in on account of his suspension. ठीक है. तो इसमें पूछा गया कि भाई हाउ द सीनियोरिटी शुड बी फिक्स इन केसेस of the above type where the for promotion of the next higher grade a minimum period of service is present but the government servant could not put in on account of suspension. और जो उसकी सस्पेंशन जो भी है वो होली अनजस्टिफाइड मिली है. ठीक है. तो इट इज़ नाउ बीन डिसाइड दैट इन अ केस द पीरियड ऑफ ट्रेनिंग विच एनी ऑफिसर जूनियर बी सस्पेंडेड. हाँ, बोलता है नाउ बीन डिसाइड दैट इन सच अ केस द पीरियड ड्यूरिंग विच एनी ऑफिसर junior to the suspended officer concerned was promoted to the higher grade should be reckoned towards the minimum period of service. क्या कहना चाह रहे हैं? It has been decided that the period during which an officer junior to suspended officer, ठीक है, was promoted to the higher grade should be reckoned towards the minimum period of service referred to above for the purpose of determining his eligibility for promotion to higher grade. Yeah, the period during which an officer junior to the suspended officer junior was promoted to this period के लिए उसका जो जूनियर ऑफिसर था ना, officer junior to the suspended officer concerned was promoted to the higher grade should be reckoned towards the minimum period of service to above for the purpose of determining his eligibility for the promotion of higher grade. It has been decided that the pay of such category of government servant should on promotion be fixed by allowing the intervening period during which the suspended officer could not be promoted due to suspension to be counted for increments in the higher grade, but no arrears could be admissible. But इस केस में क्या है, arrears admissible नहीं होंगे यार. ठीक है. These concessions will also be admissible to those governments who, though not under suspension, could not be promoted to the higher grade on account of their implicitly account of their conduct being under the investigation who were subsequently completed exonerated. ठीक है. हालांकि समझ में नहीं आ रहा दैट द पीरियड which any officer junior to this suspended officer was promoted to the higher grade, जिस पीरियड के लिए किया गया ना हायर ग्रेड शुड बी रेकन, वो माना जाएगा टुवर्ड्स द मिनिमम पीरियड, कि वो कम से कम मिनिमम पीरियड माना जाएगा ऑफ सर्विस रेफर टू अबव फॉर द पर्पज ऑफ डिटरमाइनिंग हिज एलिजिबिलिटी फॉर द प्रमोशन ऑफ हायर ग्रेड. ठीक है. राइटिंग ऑफ कॉन्फिडेंशियल रिपोर्ट्स इस तरीके से आपको बाय ऑफिसर अंडर सस्पेंशन, राइटिंग ऑफ कॉन्फिडेंशियल रिपोर्ट्स बाय ऑफिसर अंडर सस्पेंशन. ओके. क्या कहता है, क्वेश्चन हैज बीन रेज्ड दैट एन ऑफिसर हु इज अंडर सस्पेंशन कैन राइट. अच्छा, वो खुद नहीं रिश्ता, नो ही कैन नॉट राइट. अंडर सस्पेंशन कैन राइट और रिव्यू कॉन्फिडेंशियल रिपोर्ट्स ऑफ हिज सबऑर्डिनेट्स. The matter has been given बोलता है, it has been decided that if the reporting or reviewing officer is under suspension, ठीक है, when the confidential report has become due to be written and reviewed, it may be got written reviewed by the officer concerned within 2 months from the date of his having been placed under suspension. ठीक है. तो it may be got written reviewed by the officer concerned within 2 months from the date of his having been placed under suspension, or within 1 month from the date of which the report was due, or within 1 month from the date on which the report was due, whichever is later. An officer under suspension shall not be asked to write review confirmation report after the time limit specified. Has now been reviewed in the light of parts of no officer is allowed to write. ठीक है, एक कार्ड इसमें इन्होंने अब कर दिया. It has been decided in partial modification of the above order that no official is allowed to write or review SCR of subordinate if during major part of the writing of the reviewing he is under suspension, as he may not have full opportunity to supervise the work of his subordinate. Extension of temporary post to a government servant under suspension. हाँ, कर सकते हैं उसमें extension of temporary post to under suspension. Yes. The question whether it is necessary to extend the terms of the post hold by an officer who is placed under suspension pending inquiry into his conduct if he is in temporary service has been engaging the attention of the common offences path. The question will arise only if it is decided to pursue the inquiry against the suspended or to its logical conclusion. Instead of terminating his service under the season rules, where an individual is due to discharge from the service on account of his expiry of the sanction, the post held by him, where individual is due to be discharged from the service on account of the expiry of the sanction of the post held by him, or otherwise become liable to be retrenched when he is under suspension. The question should the question whether he should be so discharged, or if an individual is due to discharge from service on account of the expiry of the sanction of the post held by him, or otherwise becomes liable to be retrenched when he is under suspension. The question whether he should be so discharged or whether he to enable disciplinary being continued, special steps should be taken to provide a post for him should be examined on the merits of the each case. Okay, that should be examined on the merits of the each case, and this is his post extended for an appointment period for a period. Okay. In this circumstance, the vacancy caused by action should not however be filled. To dismiss or remove an officer concerned from the service may, in such circumstances, issue orders extending the post. The authority competent to dismiss or remove the other may, in such circumstances, issue orders extending the post without reference to higher administrative authority. Ordinarily competent to sanction such extension to the finance or to the finance. Ordinarily competent to sanction such extension or to the finance ministry if delay is anticipated in obtaining sanction before the expiry of the term of the court. Otherwise, the sanction should be obtained as usual. Okay? Otherwise, the government authority should be obtained as usual. बोलता है an individual is due to be discharged from service on account of expiry of a sanction post held by him. बोलता है an individual is due to be discharged from service on account of expiry of a sanction held by him or otherwise becomes liable to be retrenched when he is under suspension. The question whether he should be so discharged or whether he to enable discipline prisoner being continued, special steps should be taken to provide a post for him should be examined on the merits of the case and his post extended for an appropriate period. Okay, in this the vacancy caused by action should not be or be filled. ठीक है, on the merits of the case, his post extended for an and is post extended for an appropriate period. The vacancy caused by the extension should not however be filled. ठीक है, vacancy जो है that caused by an extension should not be filled. The authority competent to dismiss or remove the officer concerned from the service may in such an issue orders in the post without reference to higher authorities. ये बहुत इंपॉर्टेंट है यार, दिस इज रियली रियली वेरी इंपॉर्टेंट. जो भी टेम्पररी केसेस के अंदर जो भी अथॉरिटी कंपोनेंट है ना, टू डिसमिस और रिमूव द ऑफिसर कंसर्न फ्रॉम द सर्विसेज may in such circumstances issue order कर देगा extend the post without reference to higher administrative authority ordinarily competent to sanction such extension or to the finance ministry if delay is anticipated in obtaining sanction such extension or the finance ministry if delay is anticipated in sanction for the expiry of the term of the post under the normal procedure. Otherwise, the sanction recommendation should be obtained as usual. The creation of temporary post and appointment of substitute in such vacancy. Creation of temporary post and appointment of substitute in a suspension. On a case recently brought to the notice of the Minister of Finance, where the administrative authority had created extra post for carriage of the work previously done by the government servant placed under suspension. The question whether it is necessary to create extra post under suspension has been examined in the Minister of Finance. We held the government where provision for leaves reserves, where position for leave reserves exist, any vacancy caused on account of suspension of government servant should be filled by a reservist. Whereas it is not available, the post should be filled by an official appointment. It is, however, not necessary to pay the post. Okay? Suspension of government servant, constitution of review committee. Suspension of government servant and constitution of review committee. Okay. Rule 10 suspension बोलता है that 96 is being amended to provide that an order of suspension made or deemed to have been made under this rule shall be reviewed by the competent authority on recommendation of the review committee. Together, Rule 10 के अंदर जो भी suspension होती है is being amended to provide that an order of suspension made or deemed to have been made under this rule shall be reviewed by the that an order of the suspension made or deemed to have been made reviewed by the competent authority on recommendation of a review committee. For the purpose, it is also being provided in the rules that an order of suspension made or deemed to have been under this shall not be valid after 90 days. There also being provided in rules that an order of suspension made or deemed to have been made shall not be valid after 90 days unless it is after a review for a further period after 90 days. And further period extension will be for a period of 180 days. Further period after exceeding 180 days. It is therefore necessary to constitute a review committee to review the suspension. The cases of a review committee may be as follows: the disciplinary authority, the appellate authority, and the another level of. तो सबसे पहले कौन होगा? सबसे पहले the disciplinary authority, ठीक है? Then the appellate authority and another officer of the level of disciplinary या फिर appellate authority from the same office. In case of वो किस केस में है? इन द केस वेयर द प्रेसिडेंट इज नॉट द डिसिप्लिन, वेयर द प्रेसिडेंट इज नॉट द डिसिप्लिन अथॉरिटी, ठीक है? और जहाँ पर जो है प्रेसिडेंट इज द अपीलेंट अथॉरिटी इज द प्रेसिडेंट एंड द डिसिप्लिन अथॉरिटी एंड टू ऑफिसर्स ऑफ द लेवल ऑफ सेक्रेटरी। यहाँ पर क्या आएगा? डिसिप्लिन अथॉरिटी आएगा and then you have two officers of the level of secretary, additional secretary, joint secretary who are equivalent to or higher in rank than the discipline authority, ठीक है? फ्रॉम द सेम ऑफिस और अनदर ऑफिस, ठीक है? अगर यहाँ पर भी बोलता है थ्री ऑफिसर्स ऑफ लेवल ऑफ सेक्रेटरी, वो कहाँ पर होगा? ऑफ लेवल ऑफ सेक्रेटरी कहाँ पर होगा? who are higher in rank than the suspended official from, who are higher in rank official from the same department, ठीक है? इन अदर केस ऑफिसर ऑफ द सेम लेवल इज नॉट अवेलेबल इन द सेम हाउस एंड ये क्या है? डिसिप्लिन अथॉरिटी जो है इस केस में इज द प्रेसिडेंट, ठीक है? पर यहाँ पर जो है अपीलेट अथॉरिटी जो है यहाँ पर प्रेसिडेंट जो है ना ही डिसिप्लिनरी अथॉरिटी है और ना ही जो प्रेसिडेंट है फर्स्ट वाले केस में प्रेसिडेंट है तो ना ही डिसिप्लिनरी अथॉरिटी है और ना ही अपीलेट अथॉरिटी है। दूसरे वाले केस में अपीलेट अथॉरिटी जो है वो प्रेसिडेंट है, प्रेसिडेंट इज द अपीलेट अथॉरिटी। तीसरे वाले केस में जो है डिसिप्लिनरी अथॉरिटी इज द वेयर द डिसिप्लिनरी अथॉरिटी, अगर मान लीजिए प्रेसिडेंट है, यहाँ पर जो अपीलेट है यहाँ पर डिसिप्लिनरी अथॉरिटी प्रेसिडेंट 3000, तो यहाँ पर ठीक है इस तरीके से होगा। जहाँ पर डिसिप्लिनरी अथॉरिटी है, अपीलेट अथॉरिटी अगर कहीं पर प्रेसिडेंट है तो उस केस में तो डिसिप्लिन टू ऑफिसर ऑफ दिस, लेकिन ऑफ द लेवल ऑफ सेक्रेटरी, एडिशनल सेक्रेटरी, जॉइंट सेक्रेटरी हु आर हायर रैंक देन सस्पेंड ऑफिसर्स, तो उस केस में जहाँ पर डिसिप्लिनरी अथॉरिटी प्रेसिडेंट है, ठीक है? द रिव्यू कमेटी may take a review regarding revocation, continuation of the suspension, keeping in view the facts of circumstances, the case also taking into account unduly broke suspension, right? While putting the employee concerned to the undue hardship involved payment of suspension allowance without the employee performing any useful service without prejudice to the foregoing, it is if the officer has been under suspension for 1 year without any charges, कहता है if the officer has been under suspension for 1 year, ठीक है, without any charges being filed in a court of law or no action memo has been issued in a departmental inquiry, he shall ordinarily be reinstated in service without prejudice to the case against him. However, in case the officer कोई भी अगर ऑफिसर जो है वो पुलिस में है, जुडिशियल कस्टडी में है, ऑफिसर इज इन पुलिस जुडिशियल कस्टडी और इज एक्यूज्ड ऑफ अ सीरियस क्राइम ऑफ मैटर इन्वॉल्विंग नेशनल सिक्योरिटी कोई दिक्कत नहीं है। However, in case of an officer is in police judicial or accused of serious crime or matter involving national security, the review committee may recommend the constitution. The review जो है may recommend the constitution of suspension of the official concerned, ठीक है? Insofar as persons serving in Indian audit or account department are concerned, these instructions are issued in consultation with the CAG, ठीक है? It may also be impressed upon all the concerned that lapsing of any suspension order on account of failure of review, the same will be reviewed very seriously, ठीक है? आपको कहीं ना कहीं it has been published in this, therefore necessary to review the pending cases, आपको क्या करना है? And that therefore it would be necessary to review the pending cases in which suspension has exceeded 90 days, ठीक है? Other suspensions cases will also to be reviewed before, ठीक है, वो भी आपको चेक करना है before expiry of 90 days from the date of suspension. Ministry Department request to ensure necessary review committee जो है constitute की जाए, review not necessary in case of continuous detention, तो बोलते हैं Provisions regarding deemed suspension have been reviewed by this department. The provisions in this had been modified as per original provision of Article 27 for review with an end was applicable to all types of systems. However, in case of continuation, review becomes a mere formality where with no consequences as the government servant in such situation has to continue to be under deemed suspension. It is therefore the review commission shall not be necessary in case of in such cases. ठीक है? It has therefore been decided that a review of suspension shall not be necessary in such cases. Accordingly, a provision has been added in this that provide that no such review of suspension shall be necessary in case of deemed suspension. ठीक है? No such review of suspension should be in case of deemed suspension. And that two, if the government servant continues to under detention at the time expected of 90 days of the from the review, will count from the date of 90 days है ना, count from the date of government servant and detained considering released from detention from the date on which the fact of his release from detention is intimated to his appointed authority, whichever is later. In deemed suspension जो है under Article 2, the date of order of suspension may be much later than the deemed date of suspension. In a deemed suspension, जहाँ पर भी deemed suspension हो रहा है under sub rule 2, ठीक है, the date of order of suspension may be much later than the deemed date of suspension. ठीक है, with a view to making these provisions explicit जो है now been amended constitute 90 days from the date of order of suspension. ठीक है, there is 90 days from the effective. ठीक है, deemed suspension में from the date of order of suspension. That notwithstanding anything contained in this, any suspension made deemed to have been under this, the rule shall not be valid after a period of 90 days unless it is extended after review for the further period of 90 days. ठीक है, तो ये क्या है, then amendment subject to the provision contained in this, an order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified, revoked by an authority competent. Okay, subject to the provisions made in content 7, in order and made deemed to have been continued shall continue to remain in force until it is modified or revoked by the competent authority. तो बोलते हैं रूल सब रूल 7 जो है अंडरस्टैंड दैट नथिंग विद स्टैंडिंग एनीथिंग कंटेन्ड इन रूल 5A एन ऑर्डर ऑफ सस्पेंशन मेड और डीम्ड टू हैव बीन made under this rule shall not be valid after a period of 90 days and it is extended after review for a further period of 90 days. ठीक है, for the expiry of the 90 days. ठीक है, तो ये वाले subject to the provision contained an order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified or revoked by the this order. ठीक है, in case of deemed suspension की बात कर रहे हैं. फिर इसके बाद होता है नोट विद स्टैंडिंग एंड कंटिन्यूअस रूल 5 टू हैव बिकम रिटर्न एंड इन सो फार एज पर्सन सर्विंग इन ऑडिट अकाउंटेंट्स, तो इंडियन ऑडिट अकाउंट सर्विस में कोई भी है तो सी ए जो है कंसल्ट करना है आपको. ठीक है, और मिनिस्टर रिक्वेस्ट टू प्लीज ब्रिंग दिस अमेंडमेंट, ठीक है, टू द नोटिस ऑफ डिसिप्लिनरी अथॉरिटीज. ठीक है, इंस्ट्रक्शन रिगार्डिंग टाइमली रिव्यू ऑफ सस्पेंशन. हाँ, वो टाइमली रिव्यू करना ही होता है आपको. रिव्यू कब करना होता है? 90 डेज के अंदर अंदर करना. रूल 10 जो आपको एक बोलता है डिस प्रोविजन may be placed on following ceremony against his disciplinary proceeding against his contained opinion जो है that he has engaged himself in prejudicial to the interest of security of state and where the cause case against him a criminal offence. ठीक है, disciplinary authority may also consider proper place on suspension are only intended for guidance. ठीक है, not to be taken mandatory. तो ये बताया आपका केस वेयर कंटिन्यूशन continuance जो है of in office of the government servant will prejudice to the investigation and trial and inquiry where the conduct to seriously subvert discipline will wider against the wider public interest में होगा. There is a public scandal that represents assessment to demonstrate where allegations have been made against for an inquiry that revealed that a prima facie अगर reason case आ रहा है यहाँ पर. ठीक है, तो in the first 3 circumstances authority may exercise the discretion. First 3 cases के अंदर में वो authority में discretion and even when the case is under investigation before prima facie case has been established. फिर बोलते हैं सस्पेंशन में भी डिजायर एनी ऑफ हिज कंडक्ट मॉरल ट्रिपिट्यूड का कोई भी काम होता है, करप्शन या एम्बेजमेंट का काम होता है, सीरियस नेग्लिजेंस या फिर लॉस टू द गवर्नमेंट डेरिवेशन ऑफ ड्यूटी, रिफ्यूजन ऑफ डेलिबरेट फेलियर, फेलियर रिटर्न नोटिस ऑफ फेलियर ऑफ. ठीक है, तो मे एक्सरसाइज हिज डिस्क्रिप्शन टू प्लेस फिर बोलता है रूल 10 6 7 डील विद द रिव्यू ऑफ सस्पेंशन within 90 days are applicable. The provision for review within 90 days are applicable to all types of suspension. However, in case of continued during the review becomes a merely formality, it has been brought to the notice that in cases of prolonged suspension, the courts have found that suspension cannot be granted for a long time. For long, and in spite of instruction DOPT, that is not finding the review within this time. Also, जो है government is unnecessarily paying suspension rather than or a government servant remaining absent without authority, etc. It did not be placed under suspension, but when the officer who is under suspension disappears and cannot be found in the last minute, the suspension should be lifted and further ordered. But inquiry may follow. Like with a government servant remaining under suspension without authority, etc. should not be placed under suspension. ठीक है, कोई बिना बताए भाग रहा है तो सस्पेंशन नहीं करना उसका. बट एन ऑफिशियल हु इज अंडर सस्पेंशन डिसअपीयर होता है और कैनॉट बी फाउंड इन द लास्ट एड्रेस, तो सस्पेंशन शुड लिफ्ट कर देना सस्पेंशन एंड प्रोसीड राउंड फॉर एक्स पार्टे इंक्वायरी में भी अलाउड. फिर बोलते हैं लिमिटिंग नंबर ऑफ सस्पेंडेड ऑफिसर्स एंड पीरियड ऑफ सस्पेंशन टू द मिनिमम. लिमिटिंग नंबर ऑफ suspended officials and number of and period of suspension to the minimum. In spite of series of instructions issued from time to time for limiting the number of officials under suspension and also during the period of suspension, there are quite good number of officials continue under suspension for condition. In order to keep the number of officials under suspension, the various members of the president instructions an official may be under suspension only in the circumstances where one to the same as GID 1. Okay, where the public servant is suspected to have amendments only in the following circumstances. Okay. Wow. बहुत अच्छा बस. ठीक है. Alright, with this, thank you so much and have a great day. I think हमारा ये क्लियर हो गया है इससे. Just thank you.